This is the Lex Beyond podcast by Lexicon Labs. I'm Lex.
And I'm Bianca. Have you seen the massive headlines coming out of Arizona? According to a breaking CNBC report, Arizona's Attorney General, that's Kris Mayes, has just filed 20 misdemeanor criminal charges against the prediction market platform, Kalshi.
20 charges. Yeah, that is definitely not just a slap on the wrist.
Right, exactly. We're talking about accusations of running an illegal gambling and election wagering operation right there in the state. Up until now, prediction markets have mostly dealt with, civil suits or regulatory wrist slaps.
Yeah, totally.
But this is an unprecedented escalation. These are the very first actual criminal charges Kalshi has ever faced.
It sounds like a catastrophic blow to their business model, doesn't it? Like a total game over.
Yeah.
But here is where we actually need to completely flip the script on what you might be thinking right now.
Okay, I am listening.
Because the state law isn't the problem. The federal law is.
Wait, really? I am going to need you to unpack that.
Right.
Because on its face, facing 20 criminal misdemeanors in a state court, that feels like an existential threat for any company, let alone a tech platform.
Well, it is loud, sure. It definitely grabs your attention. But what we are doing today is taking a deep dive into this foundational document called the Arizona Divide.
Right, our main source for today.
Exactly. And we're looking at it alongside this breaking CNBC news to reveal exactly why Arizona just, skipped the line. The state of Arizona is essentially trying to brutally enforce a law before the actual legal foundation of that law is even settled.
Oh, interesting.
Yeah, the real underlying threat to prediction markets like Kalshi isn't actually happening in a Phoenix courthouse. It is a dormant federal trap that everyone just seems to be ignoring.
I love when we get to look behind the headlines like this. So let's break down the logic here, moving from the initial shock of these criminal charges to this fundamental legal tug of war taking place behind the scenes.
Let's do it.
Looking at the Arizona charges specifically, they filed 16 counts of accepting sports bets without a license, and then 4 counts of election betting, which, Arizona law separately and explicitly forbids.
Right, they draw a hard line there.
And it is not just Arizona getting aggressive. Multiple states, including Michigan, Massachusetts, and Ohio, they've all been filing these civil suits.
Yeah, it's becoming a real trend.
They are all essentially claiming that they, the local state regulators, have ultimate jurisdiction over sports betting. Attorney General Kris Mayes even put out a statement saying, quote, "No company gets to decide for itself which laws to follow."
Which, that plays incredibly well for the camera, sure.
Oh, absolutely. Great soundbite.
But Kalshi's defense is entirely built on a totally different legal reality. They argue that they aren't offering casino bets. They aren't running a sports book at all.
Then what do they claim they're doing?
They offer what are called event contracts. Now, to make sure we are all on the same page, we should probably clarify what an event contract actually is.
Right, because the terminology gets incredibly murky here. Like if I go to a casino and I bet $100 on the Kansas City Chiefs to win the Super Bowl, that is a traditional sports bet.
Classic gambling.
But Kalshi doesn't frame it that way. They structure it as a binary option. You buy a contract that asks a yes or no question. Will the Chiefs win the Super Bowl?
Exactly, yes or no.
If they win, the contract pays out $1. If they lose, it pays out $0. Kalshi calls that an event contract. And because of that specific financial structure, they claim they're strictly regulated by a federal agency, the Commodity Futures Trading Commission or the CFTC.
That structural difference is literally everything to their legal strategy. And Kalshi has this very specific playbook for dealing with these angry state regulators.
What's the playbook?
Well, gaming attorney Daniel Wallach tracks these cases meticulously. And he describes Kalshi's modus operandi as the preemptive lawsuit.
Oh, the preemptive lawsuit.
Yeah, they try to, in his words, win the race to the courthouse.
Meaning they don't wait to be sued. They actually sue the state first to block them from enforcing local laws.
Exactly. They go on the offensive.
And looking at the track record, it has been a bit of a mixed bag. They actually won that race in New Jersey and Tennessee, securing these preliminary injunctions against those states.
Right. Those were big wins for them.
But recently, they hit a brick wall. In Arizona, federal judge Michael Liberty just denied Kalshi's request for a temporary restraining order.
Yeah, that was a huge setback.
And similarly, a federal judge in Ohio, Sarah Morrison, recently ruled against them too. She stated that Kalshi's concerns were, quote, dwarfed by Ohio's interest in exercising its police power to regulate sports gambling.
Which is a really strong phrasing from the judge.
So, to help clarify this whole jurisdictional mess for you listening, it feels a bit like imagine a local traffic cop trying to pull over a cross country bullet train that's running on federal tracks.
Oh, that's good.
All while the train company is actively suing the town to say, hey, the local cop has absolutely no jurisdiction here.
That is a brilliant way to visualize it. The local cop is claiming authority over the federal tracks. And if we look at historical precedent, which the Arizona Divide document lays out beautifully, the train company actually has a valid point.
Really? So the federal argument holds water.
It does. The state's problem with taking action against prediction markets has always been the preemption question. Does federal law preempt state law here?
And what's the answer?
To understand the answer, we have to go all the way back to 2008. Alper Ozgit, the CEO of Lexicon Labs, was in front of the CFTC discussing two sports-related futures products.
And we really need to look at what those products were because, a lot of people just assume betting on sports is automatically a state issue, like purely for entertainment.
That is the common assumption, yeah.
Yeah.
One product was an index future tracking the revenue generation capabilities of sports franchises. Think about a stadium vendor who relies on a team having a winning season to sell hot dogs and merchandise, right? If the team has a terrible season, the vendor loses money.
Right. Fewer fans in the seats.
So this index future allowed them to hedge that financial risk. And then the other product was an event contract predicting which city would host the upcoming Olympics.
Oh, okay. So again, not a game outcome.
Right. Imagine a local real estate developer who buys land hoping their city wins the Olympic bid. If the city loses the bid, the land value plummets. The event contract acts as an insurance policy.
So these were essentially risk hedging tools.
Exactly, which is exactly what the futures industry is built for, not entertainment vehicles. Now, crucially, the CFTC back in 2008 didn't look at these applications and say, oh, this involves sports, so this belongs to the state gaming commissions.
It didn't pass the buck.
No. They said, sports is a massive multi-billion-dollar business, and therefore we have jurisdiction.
Wait. If the federal government planted their flag in sports as a commodity way back in 2008, why are local prosecutors in Arizona suddenly acting like they own the jurisdiction today?
That is the million-dollar question.
We really need to explore the flaw in the state's historical arguments here, because there's a very dangerous legal precedent at play if we suddenly let individual states regulate these national financial markets.
So the states lean incredibly heavily on the argument that they have historically regulated sports gambling.
Right. They claim it's their traditional domain.
But that is largely a myth. The Arizona Divide document points to Charles Feen Lehman's concept of the new vice economy to totally dismantle this idea.
The new vice economy, what does he mean by that?
Well, if you turn the clock back just a few years to January 2016, sports gambling was illegal essentially everywhere outside of Nevada. It wasn't until the Supreme Court struck down that federal ban, the Professional and Amateur Sports Protection Act in May of 2018, that widespread sports betting even existed in this country.
That really wasn't that long ago.
Not at all. So this idea of a long, historic state tradition of carefully regulating sports gambling, it simply doesn't match the historical reality. It is a very recent phenomenon.
It's essentially a manufactured history to
justify a modern power grab, exactly.
Wow. And it brings up a critical issue when we look at how courts interpret the law, because judges always look for what's called a limiting principle when deciding these jurisdictional cases.
Right. Where does it stop?
Exactly. If your legal theory can meaningfully distinguish one thing from another, you don't really have a solid theory. So if states can claim jurisdiction over sports event contracts just by labeling them gambling, what stops them from claiming jurisdiction over election contracts?
Nothing stops them.
And we aren't just speaking hypothetically here. Look at the 4 election charges in Arizona or a recent proposed bill in Minnesota that explicitly attempted to cover both sports and elections under state purview.
The limiting principle is entirely absent. The moment you allow a state to redefine a federally regulated financial contract as gambling, the boundaries completely dissolve.
So what's the logical conclusion of that? Like, if a state can suddenly claim jurisdiction over sports and elections under the guise of gambling, what's next? Do they claim they regulate weather predictions?
Which, by the way, farmers use all the time.
Right. Farmers use weather derivatives to hedge against crop failure. Do states try to regulate energy futures, interest rates? Where is the line?
There wouldn't be one.
If everything involving risk and a future outcome can be framed as a bet, Could a local prosecutor in Arizona suddenly shut down a national hedge fund just because they don't like how they are trading oil futures?
That is the exact chaotic scenario we are barreling toward. And if you want to know what that actually looks like in practice, you just have to look at the economic history of the 1960s and early 1970s.
What happened back then?
Back then, we had 50 different states pulling in 50 different directions. Imagine you were a broker in Chicago trying to trade agricultural futures.
Okay, picturing it.
A specific contract might be completely legal in Illinois, but the moment you cross the border into Iowa, the local authorities might consider that exact same contract to be an illegal wager.
What a mess.
It was an absolute nightmare for interstate commerce. There was no centralized oversight, no underlying principles. Businesses simply couldn't predict which laws applied to them.
Which is exactly the kind of friction that federal oversight is specifically designed to eliminate.
Precisely. This exact threat of 50-state chaos is why Congress enacted the Commodity Futures Trading Commission Act of 1974.
Oh, so that's when the CFTC was born.
Yes, it is the very reason the CFTC was created in the first place, to preempt the states and create one unified set of rules for the entire country.
Makes sense.
And anything that was somehow left out of that original 1974 act was swept up by the Commodity Futures Modernization Act of 2000.
So they closed the loopholes.
Yeah, that expansion was comprehensive. The legal causality was clear. Congress wanted to centralize the oversight of all modern financial instruments. Everything, including the business of sports, was essentially declared a commodity to ensure that local authorities couldn't interrupt national markets.
So what the states are doing now, with Arizona leading the charge criminally, is trying to reinvent a very broken wheel that Congress already fixed decades ago.
Exactly. They are fighting a battle that was settled in the 70s.
But this is where the narrative takes a really fascinating turn, though. Because if we establish that the states are encroaching on federal territory and creating this entirely preventable mess, we have to pivot to the ultimate irony of this whole situation. The twist. Because Kalshi isn't actually innocent in all of this. They are still operating illegally, but they are operating illegally under federal statutes, not state laws.
This is the part that everyone is missing while they are staring at the flashy Arizona headlines. Let's look at how the CFTC handled things, or rather didn't handle things, under the Commodity Exchange Act and the Dodd-Frank Act of 2010.
Right, Dodd-Frank. Following the 2008 financial crisis, Congress was terrified of unregulated derivatives.
Exactly. So Dodd-Frank took a very hard line on what is called off-exchange swap trading.
Let's do a quick definition there for anyone who doesn't live and breathe financial regulation. What exactly is off-exchange swap trading?
Essentially, it is when two private parties make a customized financial contract with each other outside of a centralized, highly regulated public exchange.
So kind of like the Wild West of derivatives.
Totally. And event contracts, by their nature, often fall under this broad umbrella. But there is a vital nuance in how Dodd-Frank addressed them. The law didn't expressly mandate a statutory ban on these sports event contracts.
Oh, so it didn't just outlaw them outright.
No, instead, it gave the CFTC the discretion to review them. Congress basically handed the agency sweeping powers to step in if these contracts were deemed contrary to the public interest.
Meaning the CFTC had the power and the tools to step in, but they weren't legally forced to automatically ban them.
That is the key distinction. And post-2018, as states started legalizing traditional sports betting in droves, the CFTC essentially dropped the ball.
They just watched it happen.
Basically, they had the statutory authority to regulate and clarify the rules of the road for these prediction markets, but they chose inaction. They didn't enforce their authority or set clear boundaries.
Wow.
So, as the Arizona Divide points out, the result is this complicated, highly predictable, and completely preventable jurisdictional mess.
And who pays for this mess? You do, the taxpayers.
Yep.
I mean, think about your own wallet. Taxpayer dollars are currently subsidizing all this expensive multi-state litigation cleanup for laws and regulatory failures that the public never even voted for.
It's infuriating when you look at it that way.
Which brings us to the actual law Kalshi should be terrified of. Because if the state law is preempted and the CFTC just dropped the ball on their regulatory discretion, what is the actual federal trap waiting for them?
The trap is a criminal statute that has literally been on the books for decades. It's called the Wire Act of 1961.
Okay, let's break that down. The Wire Act was written in 1961. That was the era of mobsters using telegraphs and rotary telephones to run illicit bookmaking operations.
It totally was.
But Kalshi is a sophisticated tech platform operating on the internet in 2026. How could courts possibly apply a Kennedy-era law to a modern futures exchange? Has anyone actually tried to test that loophole?
Oh, it has absolutely been tested, and the language of the law is surprisingly resilient. The Wire Act is actually shockingly simple.
What does it say?
It states that if you are engaged in the business of betting or wagering, and you knowingly use a wire communication facility, which today unequivocally includes the internet and mobile apps,
Obviously.
for the transmission of bets or wagers on any sporting event across state lines, you are committing a federal crime. Period.
Yeah.
We are talking about penalties of up to 2 years in federal prison.
So it's not just a fine, it's actual prison time. No, Kalshi's obvious defense here is going to be semantic, right? They are going to point to their terminology and say, hey, we aren't betting or wagering, we aren't bookies, we are a sophisticated futures market offering event contracts.
That is exactly what they will say.
But to use the classic legal analogy, courts usually rely on the duck test, right?
Pseudo test, yeah.
If an event contract quacks like a sports bet and walks like a sports bet, the Department of Justice isn't going to care if Kalshi prints the words commodity future on their website. It's like you can't just slap a futures market name tag on a blackjack table and tell the feds it's not a casino. Courts aren't that easily fooled.
They absolutely do not care about the name tags. And we know this for a fact because it has been tried before. This brings us to a critical historical precedent, the case of Jay Cohen and the World Sports Exchange.
What happened with Jay Cohen? How does his story map onto what Kalshi is doing now?
Well, Jay Cohen was a brilliant stock options trader who thought he found the perfect loophole. In the late 1990s, he set up the World Sports Exchange offshore in Antigua, thinking he was outside U.S. jurisdiction.
Okay, pretty standard offshore move.
Right. And he tried to offer sports futures to Americans over the internet. He used the exact same semantic defense Kalshi is using now.
And where did he end up?
He was arrested upon returning to the U.S. and went to a federal prison. In Nevada, no less.
Oh, wow.
Yeah. The courts looked at the World Sports Exchange and established a very clear, enduring precedent. Courts look at the substance of the transaction, not the form or the label the company puts on it.
You can't just slap a new label on it.
Exactly. You cannot skirt federal law by simply relabeling gambling as a commodity future. It's a completely circular argument. There is absolutely no statutory exemption under the Wire Act for futures products.
None at all.
None. If the underlying mechanism functions as a bet on a sporting event, the Wire Act applies, regardless of the financial jargon surrounding it.
So, under the duck test, no matter how many times Kalshi prints the words event contract on their marketing materials, if the substance of the transaction is a wager on a sports game transmitted across state lines via the internet, they are violating the Wire Act.
That's what the precedent says.
And this isn't just a fringe legal theory cooked up by prosecutors, It actually aligns perfectly with public common sense. The CNBC report mentions a recent poll released by Ipsos and the American Institute for Boys and Men.
Oh, yeah, I saw that.
It found that 61% of Americans view event contracts on prediction markets as gambling, not investing.
Which is a huge majority.
And if you think about the psychology of it, it makes sense. The line between risk hedging and entertainment is incredibly thin for the average retail user. When a user logs onto an app to put money on an election outcome or a football game, they aren't hedging against a real estate investment like the Olympic Stadium developer we talked about earlier.
No, of course not.
They are playing the odds for entertainment and profit. The public sees the blackjack table, no matter what the sign above it says.
And lawmakers are seeing it too. The legislative walls are closing in just as fast as the legal ones. There is currently a bipartisan bill introduced in the House of Representatives aimed specifically at prohibiting event contracts on sports unless a state specifically permits it.
Oh, so they are trying to codify it.
Yes. Furthermore, that same bill would outright ban election prediction markets entirely. Even CFTC Chair Michael Seelig recently told CNBC that the agency is going to require these platforms, which currently just self-certify their own compliance, to do a much better job restricting contracts that encourage manipulation.
So the feds are finally waking up.
The federal government is absolutely waking up to the reality of what these platforms are doing.
So what does this all mean for you, listening to these massive headlines and trying to make sense of all this regulatory noise? Let's summarize the core realization of our deep dive today. Arizona's criminal charges against Kalshi are incredibly loud. 20 misdemeanors get your attention, and they make for great television for the Attorney General.
Great sound bites.
But they are aimed at the completely wrong target. The states are jumping the gun on a preemption debate that they are almost certainly going to lose.
Yeah, eventually this jurisdictional mess is going to hit the Supreme Court.
Mm-hmm.
And based on the history of the CFTC Act and the Commodity Futures Modernization Act, the Supreme Court is very likely going to tell the states to back off, recognize federal preemption, and just mind their own business.
And this is the critical, but that changes the entire story. Winning against the state of Arizona doesn't magically make Kalshi a legal business.
Not at all.
Even if all 50 states are forced to retreat, Kalshi still has to face the music regarding the CFTC's historical inaction and the brutal, unyielding reality of the Federal Wire Act.
Right, and that brings us to an incredibly powerful quote from the Arizona Divide document. It frames this whole convoluted mess perfectly.
Which quote is that?
Well, we all know the foundational American phrase, taxation without representation. But the document says, quote, taxation with representation is where progress runs in reverse, end quote.
Because of the regulatory failures.
Exactly. Because of federal regulatory agencies dropping the ball, we are normalizing outcomes that we, the actual voters, never asked for and never voted for. And worse, we are footing the bill for the messy, multi-state litigation cleanup required to fix it.
It is the absolute definition of an absurd result in the legal system.
It really is.
It really is. And it leaves us with a final, somewhat unsettling thought to ponder as we wrap up here. We spent all this time talking about the legal mechanics and the jurisdictional battles, but let's look at the broader real-world impact.
Good.
Right now, major financial institutions, hedge funds, media outlets, and even political campaigns are starting to rely heavily on the data and market forecasts generated by these multi-million-dollar prediction markets.
Oh yeah, you see it everywhere.
You turn on the news, and anchors are citing Kalshi odds as the literal probability of an event happening. They treat these odds as a form of ground truth.
Like it's hard data.
But if these platforms are ultimately struck down by the federal government as illegal gambling operations under the Wire Act, what happens to all that data?
That's a great point.
If the underlying mechanism of the market is flawed and fundamentally illegal, doesn't that taint the forecasts it produces?
Yeah.
Are we currently building our most important financial and political strategies on a foundation of illegal bets?
It is the terrifying question. If the machine generating your truth is broken, the truth itself has to be called into question.
Exactly. It brings us right back to our bullet train analogy. The train company might successfully sue to keep the local Arizona traffic cop from pulling them over. They might even win that race to the courthouse and get their injunction.
They might win the battle.
But they are completely ignoring the fact that the federal government owns the tracks they're driving on, and just a few miles down the line, the bridge is completely out. Thanks for joining us. We'll catch you next time.